You'd be shocked how quickly a first-time DUI in Oklahoma can go from a misdemeanor to a felony. I've had people walk into my office thinking it was just a ticket and leave realizing they're staring down years in prison. And if you don't know how Senate Bill 54 changed the rules, you can miss the one detail that turns your first-time DUI into a life-changing felony conviction. I'm John Cannon, a criminal defense attorney here in Oklahoma, and in this video, I'll break down exactly when and how a first-time DUI can now be charged as a felony, so you know what the law really says and how to protect yourself, your record, and your future if it ever happens to you. Picture this. It's a Friday night in Oklahoma City or Tulsa. You had drinks. Maybe you feel fine. You're driving home and you're moving with traffic. Maybe you're a little fast. A cop lights you up. Now, here's where the twist happens. Even if you've never had a DUI in your life, if one aggravating factor is present, Oklahoma cops will treat it as aggravated DUI. And an aggravated DUI is a felony under Senate Bill 54. And once that happens, you're not just dealing with embarrassment and fines, you're dealing with mandatory jail time that a judge can't just wave away. What Senate Bill 54 changes? So let's get crystal clear. Senate Bill 54 took Oklahoma's DUI law, specifically Title 47, Section 11902, and created a new felony lane called aggravated driving under the influence. It became effective November 1st, 2025. And the rule is simple. If someone is convicted of DUI and the situation includes any aggravating act listed in the law, that DUI becomes aggravated DUI and is a felony offense. The aggravating triggers that flip a first DUI into a felony. So, what are those aggravating acts? This is a list you want to memorize because it's where first-timers get blindsided. Trigger number 1, reckless driving. Reckless driving counts. That's explicitly listed. And yes, reckless can be argued about in court, but you don't want to be the test case. Trigger number 2, a passenger under 18. If you're driving under the influence of the passenger younger than 18, that's an aggravated DUI trigger. This is the one that hits families the hardest because it doesn't require an accident, it doesn't require injury, it's just the kid being there. Trigger number 3, speeding over the threshold. This one is painfully specific. More than 20 miles per hour over the speed limit or more than. 10 over in an active school zone is a trigger. So if you're thinking, I'm not swerving, I'm just getting home, this is where Oklahoma says, nope, felony DUI lane. Trigger number 4, eluding police. Driving while eluding a police officer is on the list. And you don't want to play cute games with, I didn't see them, if it turns into a chase narrative. Trigger number 5, certain traffic law violations. This is a big one. The law lists specific traffic statute sections, meaning certain driving behavior while DUI can be used as an aggravator. This is why a stop that starts as basic DUI investigation can level up fast once the report gets written. Trigger number 6, causing a motor vehicle incident that requires a report. If you cause a motor vehicle incident that results in a report, that's on the list. So even a small crash can become a huge legal problem if it generates the kind of report the statutes reference. Trigger number 7, a blood alcohol content of 0.15 or higher. And this is the classic one. A blood or breath alcohol concentration of 0.15 is more than a trigger. You'd be surprised how common it is. This nearly twice the legal limit often shows up after just a few strong drinks over a short period of time, especially with larger pours or impaired judgment. Mandatory penalties if charged as aggravated DUI. So that's the list. Now, let's talk about what happens after the list, because this is where the consequences become non-negotiable. If you're convicted of aggravated DUI in Oklahoma, Senate Bill 54 says the sentence includes mandatory minimum jail time. For a first-time offense, the first 10 days are not subject to probation, suspension, or deferral, and they can be served as night or weekend incarceration in some situations. For a second offense, the first 30 days are mandatory jail time, also not subject to probation, suspension, or deferral. And after that, the mandatory minimum portion increases by 30 days in jail for each subsequent conviction. Plus, Senate Bill 54 requires an ignition interlock for a minimum of 180 days for aggravated DUI. And at least 1 year of supervision and periodic testing is built into the aggravated DUI sentencing structure. So we've got the triggers and we've got the penalties. Now, let me make this real with a few Oklahoma flavored scenarios that show how fast this can escalate. Scenario 1, you leave a Thunder game or dinner in Bricktown. You're driving home. You're at 75 and a 55 because the road is open and you're trying to beat traffic. If law enforcement believes you're under the influence, going 20 over the speed limit alone can be an aggravator, elevating your first-time DUI into felony territory. Scenario number 2, you're a parent. You have a few drinks at a friend's house. You tell yourself you're good to drive home. So you load your child in the car and head home. Minor in the vehicle, That's not just a bad look, that is explicitly on the list. Under Oklahoma Senate Bill 54, driving under the influence with the child under 18 in the car can elevate a first-time DUI to a felony. And the law also allows the fines to be enhanced, even doubled. Scenario number 3, you clip a curb, you tap a parked car, or you bump someone in stop-and-go traffic on I-40. Nobody's hurt, you think, this is just insurance. But the moment that becomes a reportable accident, it can also act as an aggravating factor. And all 3 of those scenarios have something in common. They're the kind of thing people brush off as a mistake, right up until it turns a DUI into a felony case. One more thing, Oklahomans ask about constantly weed. Oklahoma's DUI law doesn't care whether marijuana is legal or not. It allows a DUI charge for any amount of Schedule I substance or its metabolites based on blood or urine tests taken within 2 hours of arrest. And Senate Bill 54 makes this crystal clear. Being lawfully entitled to use marijuana, whether recreational or medical, is not a defense to a DUI charge. That surprises a lot of people, and it's one of the fastest ways first-time drivers accidentally walk into felony exposure. Here's the simple takeaway for Oklahomans. Senate Bill 54 didn't just increase penalties, it changed the category of risk, because now behavior people brush off as not that serious, speeding over the threshold, a reportable incident, or having a minor in the car, can flip a first-time DUI into a felony aggravated DUI. And once that felony lane opens, you're no longer negotiating around fines, you're dealing with mandatory jail time, mandatory restrictions, and long-term consequences that don't just disappear. Now, I just explained what turns a first DUI into a felony, but the next question is, what do you do if the stop turns into something even bigger? Because a lot of people don't realize how fast a simple traffic stop can become a weapons case. And the choices you make in those first few moments can decide whether you walk away or get charged. So click the next video titled, How to Beat a Weapons Charge. I'm going to break down what actually matters, what cops look for, and the mistakes that hand the prosecution an easy win, so you don't get blindsided twice.